Hi, everyone. Carl Steinbeck here, covering down from New York City tonight. Leslie and I are in a travel status here, so I tried to live stream last night, but I didn't have the right mouse with me from Texas, so had to go out and buy one today. But also thought I had the other nice camera John got me, but didn't have that here available, so I'm just using my laptop here tonight. But everything should be working technically as of now, so that's why I wasn't on last night. So I haven't been on since Friday. Actually, Thursday night. It's the last time I covered down on this case. So I would like to go ahead and jump right into the prosecution's closing argument rather than going through the defenses. I can maybe do that one tomorrow night. So I would like to just go ahead and go to the start of Brennan's argument. I also want to talk about the verdict form. I've not been able to see an actual copy of that. If you guys, I've seen it on channels, but I've not seen the actual copy. If somebody could email that to me at jurytrialmentor.com, because there's some stuff I could talk about there that is important. I know there's some questions about why the defense added the DUI instruction, and I did say that I thought that was a move I would have made just for reasons I can give later as well. But if anybody does have a hard copy of that, they can email it to me. Like I say, jurytrialmentor@gmail.com. So let me go ahead and go here to the closing argument hosted by Travel.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in.
Okay, right off the bat, my sense is from an advocacy standpoint, trial attorney like this does have the ability to walk around. He's not reading off a script, which I think is usually not the best option. And you got a lot of details in this case here, so I'd probably be relying more on having a presentation on the screen and then walking the jury through that and be looking at them as you're doing this. So he's walking sort of like he did in his opening, where he's walking with where he's like perpendicular to the jury. So I don't think that's a good thing, but he makes a correction of that here as he goes on. But he sort of has a really stern tone. I think he has sort of an angry tone, and that's sort of like something that I think doesn't sit well with jurors. If you sort of come off as angry and the whole time you're angry and loud in your tone, and we'll talk more about that later here.
He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world, but to give him a chance. And that.
Funny mentions Isaac Wolf, because Isaac Wolf is down in Miami. They never called anybody from the local area there. And Boston has some of the best medical care in the world. So very strange that he called somebody from Miami and had to pay him all that money to leave their practice. But then again, keep in mind what Dr. Wolf said. Dr. Wolf never attributed the injuries of John O'Keefe to a vehicle strike.
One person who could help him that morning was this defendant right here, Karen Green.
Okay, what about all those other people at 34 Fairview that are coming and going from the house? What about them? What about people that lived at 34 Fairview? Jury might be thinking about them as well. They've been out to the house. They know how close that location is to the front door. They've seen through testimony whose window was right to the left of the front door, closest to John O'Keefe's body.
And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard.
Debris field laying all over the front yard, yet nobody could see it that night and that morning. It took him many hours later that day and over several weeks. So he's already missing a lot of the details. And he's not talking about things sequentially, and he's not talking about what actually proof there is of this, what witness said what.
She made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision.
There was no collision, so how would she know that? What proof do you have she had knowledge that she hit him?
About herself. In her Lexus, she drove away. She was drunk. She hit him. And she...
Okay, he's telling a story now, but he's not developing the facts, how that led up to this. So he's trying to get like the jury whipped up into thinking, oh my gosh, she's some psycho killer. But he didn't lead you the details of how to get to these conclusions.
Left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence.
And nobody saw him laying in the yard there till after 6 in the morning. So how are you going to explain that, Mr. Brennan?
Let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking McCarthy's.
So jurors, as they're listening to this guy talk, if you leave out all these big details like that and you just jump right away to the conclusion of what you say happened under your government prosecution theory, but you leave out all these other details, I think the jury's got to be thinking to themselves, well, what about these other things that you're sort of glossing over and ignoring?
John, she was drinking at the waterfall. Her blood was taken with samples of the retrograde analysis, almost 2 to 3 times the legal limit.
Okay, let me talk about that. 2 to 3 times legal limit. If Karen was drinking last around 12 o'clock, and then she drove to 34 Fairview, and then she left 34 Fairview and then made it back to John's and stayed there until she then made it back to 34 Fairview with the other two, Jen and her friend. Then think about how alcohol is absorbed by the body and is eliminated from the body. So for a general average sized person, for every beer or every shot of hard liquor that they have in a mixed drink, the elimination from your system takes about an hour. So if she had, let's say, 6 shots worth of alcohol that night, for an average person, it would be completely eliminated from their body 6 hours later. So 6 in the morning, she would have basically zero blood alcohol content. And then she didn't actually get tested until 9 o'clock in the morning. So this is something that, to me, leads us to the firm conclusion that she was still drinking after she got back to John's, because otherwise there's no way that, based on what we heard about how much she had to drink that night, that she would still have 2 to 3 times the legal limit. I mean, that's almost like a lethal amount. So this is something that doesn't make any sense.
She was drunk. She hit him.
The pharmacist said she looked fine, had no issues with her, talking to her, no slurred speech, mush mouth, none of those kind of things you see somebody drunk has that kind of behavior. So now Karen did say that she had something to drink, and she felt like she shouldn't have driven on the interstate, and she didn't drive on the interstate. So she made it sound like she maybe had a little bit more than she should have, but she never said anything about being drunk.
The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data.
I got the verdict slip now, so thank you if you guys are still looking for it.
The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him.
That's not what that shows. That doesn't show any vehicle strike on John O'Keefe. You can have all kind of computer programs in a car and a phone, all kind of stuff. That's not what that stuff is designed to do. It's not designed to show location of people and when somebody was hit by a vehicle. So it's not even designed to do that. And we all know computers have glitches all the time.
Because he never moves again. His healthcare data, the temperature on the battery of his cell phone, the physical.
He did move after this so-called strike happened, according to your theory.
And it's the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, countercoup. You heard all about it when the back of his head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help.
Yeah, it sounds like he wouldn't have even had a chance, even if he got help immediately. So that's a little misstatement right there.
And if you don't,
because we heard from Dr. L, I'll call her. She said that he had 15 minutes, 20 minutes at most. So getting to a level 1 trauma center, that wouldn't have happened. There's no way first responders could have gotten him to a level 1 trauma center within that time window. So I disagree with what he's saying here.
You develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk.
He is looking at a little bit off his notes here, doing that side pace. He is making more eye contact with the jury, but he's doing some side pace here. But he seems to be going off of memory more than he has a script. So.
And that night was a.
But the thing is, I noticed also he's never really tried to connect with the jury when he's been in trial. In his opening, he wasn't. When all the questions are coming out, once in a while I see him stand back, leaning against his back bar, the railing there, and then look over at the jury. But it didn't look like he was trying to make any kind of eye contact with them or paying attention to him during this trial. So this is the most, after 7 weeks, that he's actually looking at the jury. So I think it's a little bit odd if this is the first time you start doing that.
Recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was
No, look at all the defense counsel, except for the one on the end there, Elizabeth Little. They're all looking straight ahead. That's normally what we see defense counsel do. They're not going to be sitting there typing away on their computers or talking to each other. They just sort of look stoically straight ahead. They're listening. They maybe take a note here or there, but they're acting like this guy isn't worth listening to. They're not going to look at him at all.
Crumbling. We hear lovey-dovey, and it was crumbling, and we know it.
Lally and the other assistant district attorney there, she's looking at him more than Lally does, but Lally really doesn't look at them all, which I think is odd, because normally you want to look and support whoever's doing the argument here. It's like they're sort of checked out and he's not worth listening to as well. Look at that guy with his hands there in his forehead. He definitely wishes he wasn't there. I think he's playing on his phone.
And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described to you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29th.
She was invested in the relationship and he wasn't. She wanted a long-term future with John and John didn't. And that's why she was trying to get things rectified with John, but he wanted to walk away and he was not having the same goals as Karen did.
In 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end.
Yeah, but John also gave her mixed signals. He at times made it seem like he was interested in her, wanted a long-term future. So he was giving her mixed signals. I think in the after reviewing all this in her mind, she's probably realizes he was giving all kinds of clues and signals that he wasn't into her long term. But at the time, he still wanted to give her a shot. At least that's what she was interpreting it as. So this wasn't a situation where she's going scorched earth on him and she wanted to end his life. There's just no indications of that.
And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keith drinks a lot, and Karen Reed drinks a lot. You've seen my coffee videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the next drinks. More shots into next drinks. Count them yourself.
Yeah, and there's no way somebody can be 2-3 times the legal limit 9 hours later. There's just no way. That's a major misstatement. And I've dealt with cases like this before. We've had to do extrapolation. So the only way she could have a high blood alcohol level was because they got faulty testing. It's not certified for any legal testing there at the hospital. And a lot of times they do wipe it with alcohol before they do the blood draw. But probably also a factor is that she was drinking at John's house. So this blood test stuff means nothing.
Half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up at the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Can we have slide one, please? At the waterfall bar, when you see John O'Keefe coming, here's him barely greeting him. That's him and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Celebratory mood. A bunch of friends. They're playing around, they're hugging, they're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
And it takes probably about 5 or 6 or 4. There's roots that they were forming at more parties, which is where you see most of the alcohol. What's the weakest time? It tasted just like all soda water with lime.
Slide 3, please.
I wanted to on the expressway. I wanted to on the expressway. I mean, it was quiet, the roads were very bright and see videos. And I was going, right by the turns, my brother was for restaurants and my alerts aren't as sharp as they should be. But I shouldn't be driving.
Thank you. Do you think she drank when she got home? When they leave the waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the owner's home. He didn't sneak into the house in the cupboard and grab a glass. From the waterfall.
Like I say, she had to have been drinking at home, or else their blood draw and their testing at the hospital is a complete disaster. It shouldn't even been admitted. It shouldn't be legally sufficient to be brought into case. It's too unreliable. If it's unreliable, it's too prejudicial to be used in a criminal case, especially when you got charges this serious as second-degree murder.
You see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, if you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV.
It was more than that. He'd been doing it for years, and in his resume and his LinkedIn, he said he's working towards a completion when he wasn't saying he was an actual graduate. So even those weren't accurate, because we heard from other sources that he's not taking a college course since 2019. So that's a major thing. The most highly recognized thing on there to make him an expert was having a bachelor's degree over any other certifications and tests he had, and that thing was an absolute farce. So don't water that down, Brennan.
But what he did is he found a key critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable.
He's not sounding as angry now, so it's easier to listen to him now, although his tone of voice still, it's hard for me to listen to this guy.
Timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said this at the beginning, it is a historian. Doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement.
He keeps calling it healthcare data, but it's not. It's Apple Health data. Even the slide says that. So I don't know why he keeps calling it health data.
And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Could I have slide 4, please?
Very close to the outbursts. In fact, when Jen was navigating John to the outbursts when I was driving, she said it's near Ashley's house. Ashley and John were hooked up prior to John and I dating.
And so they travel to 34 Fairview under the duress of this crumbling relationship, fueled by intoxication. We have triggers. Now, we know on their way there,
Was the duress of a crumbling relationship? Why was she upset to find him? Why was she worried about him? Why is she the only one that showed concern of him laying there in the yard?
we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide, you could enlarge that symbol, please, and it shows you with the healthcare data. It registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you can move down to his installment. And then the bottom left, that's 34th Fairview. You can see, second by second, the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess, and because of Doug Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. Disorder comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms, like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We have all the arguments we want. They're there, they're together. The data matches up perfectly. Perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the...
Yeah, I don't have an iPhone, but different comments like I see on this. Different phones do different things. And so to say all this is like ironclad and there's no variables and everything works perfectly as it's supposed to, it just doesn't happen. I mean, even with StreamYard, I have glitches and stuff isn't doing what it's supposed to do.
The flagpole, we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason, at Cedar Crest, at that intersection before it goes down to the right, they meet, they let Karen Reed go first, they follow behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning and the end of his life. And he's in that car. He's in that car for most of it. Because Miss Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30.
Even Jen McCabe, the vehicle was directly out past the front door of the house at 34 Fairview. It was not up by the flagpole. And it was that way until 11:45. We have 11:36. Jen's already connecting back to John's Wi-Fi back at Wen Meadows, and that's like a 6.5 to 7 minute car drive.
30. Remember, Ms. Mason and Ms. Nagel said they're about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56.
Pay attention how much Brendan is pounding the table, doing like this, making aggressive noises like that. And that's something I would be objecting to if he's trying to get this jury riled up by actually being making sounds of violence like that. I don't think that's acceptable behavior for prosecutors on a crime of violence that you're arguing is
It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly what John O'Keefe is. What he said is it was meetings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves to 20 seconds, it turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. They never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data.
obviously the implication is there that something else happened to him other than what you're saying. That's how he got out to the flagpole.
"20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing, it could be a straight line, it could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail and every little second. We don't have to. That's not dealt. That's not reason.
We don't know every little detail. We don't have to. You better be able to explain to the jury exactly what happened. And what you're doing is just glossing over massive issues that involve scientific proof, medical proof that John O'Keefe was not struck by any vehicle, let alone Karen Reed's vehicle.
Reasonable doubt. We know for that 20 seconds he's moving, and in that 20-second window, when he moves, he has his phone, he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message, and he closes it.
He would not have the ability to do that function, number one. And number two, Jen McCabe kept on looking out of the house. Every time she sent a text, she's looking out of the house. Isn't it odd she never sent a text message to Karen or tried calling Karen like she was calling John O'Keefe all those minutes? She was incessant about calling him, and she kept on pressing, trying to reach him either via text messages or phone calls. A reasonable person would have stepped outside, especially when she said, "Pull up right behind me," implying that she knew he was there outside. And so Jen knew that there was a reason why he's not coming inside. What's going on? She would have gone outside to look. At a minimum, gone outside to look and or calling Karen because he's not answering.
And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home.
They already know your theory, Brennan, so why don't you talk about what you got for proof that establishes all this? Talk about the proof and how the vehicle actually made contact. You're not going to want to talk about those facts.
She could have broken up with him. They could have talked about it the next day. But like knocking on the door, like Kaylee said, getting the last word, she doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it until he...
Yeah, see how he's trying to like smash his hand on the lectern there? That's not a good move. And looking angry like that, you're just not coming across well. He's sort of pacing like he's angry also. He doesn't have composed posture in the delivery of the argument. So he's coming across as like an angry person here, like he's desperate. Like he doesn't believe what he's telling.
Reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case.
Yeah, he just stood there waiting for her to drive back so he could get hit, and he stuck his arm out there like Mr. Blue Man so he could get hit. That sounds really, really realistic. Doesn't sound based on reality at all. That he would have just stood there waiting for a vehicle to spin out, driving 24 miles an hour. None of that makes any sense.
And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Canoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Miss Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we
She didn't intend to hit him. Okay, that's nice.
are obligated to prove, and what we have proven from the evidence in this case of second-degree murder, is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and if that conduct would create a clear and plain likelihood of death, then she is guilty of that crime.
No, you have to prove that she actually hit him. You have to prove she actually hit him, Brennan. That's a big gap you're missing there. She could have gone reverse in 100 miles an hour. If you can't prove that she hit him, you don't have a case.
Whatever the label is, she would be.
That's a real big misleading comment there, folks. He has a burden to prove that the vehicle actually struck John and did that damage to him. He's just completely blown it.
With that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge and they see cars going by and they have a boulder and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they'll throw the boulder off the bridge.
Okay, I'd object right here. I mean, he's talking about this is similar to someone taking a boulder. How many people can lift a boulder? That's how outrageous this guy's embellishments are. A boulder. Who here can pick up a boulder, Mr. Brennan? Your lies about the evidence is about as big as a boulder and as heavy as a boulder, but that's not what we got here. And the reason, let's listen to the rest of this. I'm concerned about him equating this to throwing a boulder off a bridge, because that's very calculated. It's very premeditated. No matter if it's a rock you can hold in your hand or something it takes two hands and you can barely lift it over the side of the overpass, there's a lot of premeditation involved in that. So for him to equate this to premeditation is really reckless, extreme, and I think it's reversible error. Defense should be objecting on this. I see Yannetti looking over here. He's like going, what? This is equated to people throwing boulders off of bridges? The guy's just lost it.
Because they want to see the car break, the thrill. And when they throw that boulder off the bridge,
thrill,
and it comes down and lands on the car, and there's somebody, passenger, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing it off. Did they have the malice to want that person dead? No.
Wait a minute. I thought it was a boulder, Mr. Brennan. Is it a boulder or is it a rock? So now you went from a boulder that weighs maybe thousands of pounds to now it's just a rock? He can't even get his story straight, even if he's doing an analogy here.
They didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death.
It's not, it is not a comparison to this for second-degree murder, and it could be one for second-degree murder if it was an adequate comparison to this. You can make the analogy, but There's no comparison of the two. And so this is really reckless in your arguments. I'm just surprised that the defense or the judge didn't cut him off. But then again, we know how the judge is rooting for the prosecution here. So I hope the jury gets that he's just being that ridiculous. Comparing this to somebody throwing a boulder off of an overpass or bridge.
When Carol Reed, in the midst of that tension and fight, after she drove away and was gone,
his voice is really cringy. This is not good for him. He's doing all that pacing, then he gets angry like this, smashing his hands together, smashing his hand on the lectern there. That's not a good look.
Engaged when she came back for the last word in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate.
Poor Mr. O'Keefe, he's back there looking over the left ear of or right ear of Brennan. It looks like he's just closing eyes going, what the heck's this guy talking about?
75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you.
He keeps telling stories. He keeps trying to talk these grand stories, making a big embellishment about it, raising his voice. Get to the real nitty gritty details of proof. What proof do you have?
That is second degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them.
Now he's using heat of the moment, right? So think about the person carrying that boulder to a bridge. That's not heat of the moment. There's nothing equating this to Karen's situation that even if you take the prosecution's theory, there's no comparison of those two things. So that's really reckless. And he should not be getting away with that.
Or not. I submit to you that is wanton. It is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers it to 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with him. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever the disturber wants, he stops moving. Carl Keefe stops moving. Forever. Forever.
He had time still after even your window of when he's supposedly hit to make movements to turn off the phone. As we heard from medical experts, he was not in any position any mental capacity to do that. So that right there, your whole theory still doesn't make any sense.
Go to slide 6, please. You'll get to see this more closely, and you can probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards.
Data's wrong all the time.
You will see distance over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed. Can't be attacked.
Look at him pointing that way towards Karen. He's really angry. It's like he's angry because he knows he's going to lose this.
ARCA, they did some crash tests on me. You know what else they do? Texting data. There's nothing about that data that is uncertain. Nothing. Could you take that down, please? When Miss Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back. But we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back, and he hits the back of his head.
All over the yard doesn't even make sense because John is, let's say, 10, 12 feet away from the curb. And so all that taillight debris is surrounding around him, and it's going to go perpendicular to where he's hit. And how would he get that far away from the curb? Like, where was he actually hit? None of these details we know. And they never found any of the taillight pieces in any reasonable time. And think about it. We also have Proctor and his ability to help shape different pieces of evidence that are favorable to the prosecution.
His basal fracture. He's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called debris field. And you've seen videos. You can't replicate the exact contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris.
What? He just said that you know what happened. You don't know any of the details. So right there, I think that is the pressure of a lot of people on social media that follow this case making fun of the Blue Man test and the way he got absolutely obliterated by Dr. Rentschler. And he set himself up, or Dr. Rentschler said there was no hit, there's no way. So all the medical folks, all the bioengineer folks say it didn't happen. And the one who did say it happened, Dr. Welcher, he used Dr. Rentschler to destroy his own testimony. And he says he never tried to recreate it. So there's not any type of physical evidence, forensic evidence, scientific evidence, physics behind it, or medical evidence. None of those line up to saying John O'Keefe was even hit at all by a vehicle at any speed, let alone 24 miles an hour.
Field. When a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12:31:56. 12:32:04 to 12:32:12 is the data which is adjusted when you reconcile the clocks with Alexis. 12:32:09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12:32:16 is his last steps. Mr. Disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. could have slide 10, please. Play that, please. Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're gonna have to ask yourself a question for charge number 3, leading scene, knowing somebody was injured and then died. You're gonna have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2, don't need to prove it for OUI manslaughter, but for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness, there was a guide, and that eyewitness tells us that she knew, and that eyewitness is Carol Reed herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
Oh, yeah, good.
I don't know what that could have been. It was howling wind. I had YouTube working on the stereo, and I thought, did he somehow try to flag me down, which was the reaction? I was hoping to God as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone and I ran over his foot and he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
That's not even making sense. She's saying what you studied the brain for object.
When she left Fairview and left John behind,
Put a mask.
she didn't think he was mortally wounded. But she knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave the Bleefield,
She never said she hit him, and you got nothing to prove she hit him. So you lose on both accounts. You're going to go by what she says. Why don't you bring up what the doctors said? You don't want to talk about them.
all over the front lawn. But she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33.
Just that DNA on the taillight, a piece of hair that can survive all those miles in the cold. You all try to put a piece of hair on a corner of a vehicle and see how long it stays on the vehicle, if you can even get it to stay there.
It's a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McKay, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voicemail 1, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground, with his cell phone under him. The warmth of his body.
And all those people leaving the house, including Lucky, the snowplow driver, several hours later, and no one ever saw him there. He would have been easy to see. You couldn't have missed him.
Cold ground, 72 degrees. They tell you the story. As this temperature plummets and that cell phone battery is compromised.
How about the person that drove the Ford Edge right within close feet of John O'Keefe? They didn't see him either. Maybe it's because he wasn't there.
So was John O'Keefe. And him and his cell phone alone on that yard. 66 degrees to 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not the same analogy. The idea that means that John O'Keefe went in the house, absurd. 66 turns to 61 is 12:53. 48 unanswered calls from the defendant. He's not in a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There'd be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day.
Isn't that convenient how the cell phone was found underneath his body the next day? What's the odds of that happening?
How would he get back outside? There would be more steps because this phone is working, but data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what a fucking murder.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information.
Jen McCabe looked out that way at 12:45. She never saw him out there. She was actually looking for him.
Nobody's called her. You'll see her phone records. And she says, nobody knows where you are?
That's a figure of speech, all right? She didn't have to check with everybody else because it was a figure of speech.
She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him.
Corny? Wait a minute. So he's saying that she knew she hit him. She didn't intend to kill him. So he knew he's laying there somewhere along the side of the road, but she's not going to offer him assistance. But yes, she's going to keep calling up and being mad at him for not answering the phone call. Does any of that even make any sense? And she's worried about him because she's thinking that he ditched her and is doing something else. So that's something that it's reasonable for her to get very upset about.
For him to die, but she knows she hit him, and now he's not responding, and she's getting nervous, and she's getting anxious.
Why would she be getting anxious if she knows where he's at and knows he needs help? Because she knew that she hit him. This guy.
And she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point.
Okay, well, even if you say that she thought she hit him and didn't realize that maybe it was as severe that he can't even pick up the phone, then she would have done something else, like drive back there or called somebody else to go look for him. But it wasn't an issue about her thinking he was injured. She just thought he was off doing something else and betraying her.
Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move.
How's that a drunken denial? I mean, if she's calling up and lighting into him, you know that you hurt him, and therefore you could be criminally responsible, yet you're going to be calling him up and calling him names and all that. You'd be playing dumb and acting like, hey, I don't know where he is at, and I don't know what happened to him. He didn't want to come out of the house, and so I just left, and I'm not mad at him. Our relationship was on the rocks anyway, so I figured, hey, this is all I'm going to take. I'm moving on. But no, she actually cared about him, was upset because she's like, what are you doing? You know you're ignoring me here. You're not being loyal and faithful to me.
After 1 o'clock, she could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning.
Maybe she was drinking for a while too, Mr. Brennan. Did you ever think about that? Maybe that's how her blood alcohol got so high. Assuming that was an accurate read.
Take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?"
Poor Mr. O'Keefe, he's just sitting over there with his eyes closed. He can barely stay awake listening to this. And much of the time, his wife, Peggy, she's just looking down. She's thinking, God, this doesn't make any sense. You haven't proven it, Hank, is what you think she might be thinking.
She doesn't call Brian Higgins. Has his number, has been texting with him. "Hey, was John at a party with you? Did you see John tonight?" She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand where she's saying, "Call Jen McCabe, call Jen McCabe." Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? "When did he leave the house? What happened last night?" No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See now.
Well, how convenient for Jen McCabe to say that. Why would she be texting John and saying, "Pull up right behind me"?
Now it's gone from panic to self-preservation. "I left him at the waterfall," and Jen says, "Left him at the waterfall? He saw you in front of the house."
Yeah, very self-serving for Jen McCabe to say that. You can't trust a word she said. She's already lied to the FBI. Are you going to talk about the FBI lie?
Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, "Carrie, Carrie, Carrie."
Why don't you talk about all the people coming and going out of the house? Why don't you do a time sequence of what would happen where John was at and what was going on? You can't do it. You can't say how he got there with any type of evidence whatsoever. Nobody knows how he got there, where he did. It's all wild speculation on your part. And you have no information, no data, nothing scientific, forensic, physical or physics-wise or engineering-wise to say anything hit John O'Keefe. So try again. You got to come up with something better than this, Brennan.
"John's dead. I think he got hit by a plow." Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. "I think he got hit by a plow."
It doesn't make any sense. Why would she keep calling up there before she fell asleep, trying to get hold of him? None of that makes sense.
And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that. For what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's.
Yeah, Jen McCabe won't be able to forget that because she had her lawyer fees adding up over these several years, having a lawyer with her every time she testifies, including sitting hour after hour after hour in this courtroom, listening and watching over her, advising her before and after she testifies.
Girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants.
She also called at 5:07 and talked to her sister, who's married to Brian Albert over there at 34 Fairview, her sister Nicole. You can talk about that? How there was a conversation for 38 seconds? A lot of things that could be discussed at that time.
Wants them to come out. This soccer mom with a perfectly normal life gets drawn.
Perfectly normal life, hiring a lawyer, lying to the FBI, coming across terribly as on the witness stand. That's a normal life. I guess.
into this whole farce. And she answers that call. She gets out of bed. The spirit and kindness
Look at how angry he's getting. Now he's doing that pacing again.
she displays to put herself in that position because someone
It's like he's trying to remember it by walking along. That's going to help him feed his memory, but he's leaving out all the important details, all the details that are inconvenient for him.
asks for help because that's what good people do. Terry Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Terry Roberts separately at that time answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07 the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no brake. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes, you take a look, you'll be able to slow it down. You'll see the exact same piece is missing. Because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's.
The taillight thing is not in his favor. Officer Barrows proves that the car was tampered with at the Canton Police Department. It was tampered with. Why would they do that? Because they didn't have the evidence they needed to go after Karen. So that right there exonerates her, the taillight piece alone, and how it was majorly blown out after they had it towed there to the Canton Police Department Sallyport. And then over the next days and weeks, suddenly all the taillight pieces are showing up at 34 Fairview. Can the jury really believe this story?
About 5:35, 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking every.
Boy, you're really screaming here. That's not really a good thing, I would say, is Lord, sounding that loud, it sort of startles you, doesn't it?
Everybody up. Jen McCabe comes down. Can't understand her. Going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Terry Roberts comes, take charge kind of person. She pulls him behind, she sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going to go back to Meadows, you're going to follow me, leave the car, I'll drive. At this point, Jen and Terry don't know each other. They only met once. And they go back to Meadows, they obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Terry Roberts, Jen McCabe, they're looking out the window, they can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview, and this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop! Let me out!" And they look around and they say, "What? Let me out! Let me out!" She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him.
You know what? You can't believe a word of that because you're getting that from Jen McCabe. And she's also influenced Carrie Roberts. So those two have already lied to a grand jury and lied to the FBI. So that's what you're going to rely on, Mr. Brennan?
She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone. So you probably heard this before, but John was like a buffalo on a prairie. It was just a lawn in a heap that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian with him, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved.
It's Apple data, Mr. Brennan. What happened to Lucky going by? What happened to people going in and out of the house, leaving the party? He conveniently leaves out those critical details. And as a prosecutor, I can tell you, you need to cover all the details. You can't have blinded justice. You can't have blinders on and just ignore critical things that don't support your theory. But these are so critical of a defect and defects for his case. So that's why he doesn't talk about them in any depth here. He should be talking about things in sequential order. He should talk about Lucky, talk about the other people in the house. He doesn't want to do that.
Since that 22nd, hasn't moved. They start shaking him. You're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the other house. The glass, well,
you guys didn't ever investigate the house, didn't even ask for consent, and that's a Boston police officer. Can you imagine if that was Karen's house? How many cops would have broken into that front door, seen what's going on? It's completely dark. You're telling me Jen McCabe didn't have suspicions if she really thought something had happened to Karen and she doesn't know about it, something drastic. And I'm sorry, something happened to John O'Keefe. He's laying in the front yard there. Who's to say that somebody in the house isn't laying in the bed or laying somewhere in the house, those similar type of injuries, dead or dying? So it just reeks of something else going on that they're not telling you.
we'll hear in the clips. If we don't play it, we'll have all the clips with you. She talks about the fact that he took her glass. He took the glass. She says it. So the Albert house, they don't need to get glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a cell record is not the same as a call detail record. There's no evidence, it was a conversation, no lights go on, there's no conspiracy. You can call somebody, it can ring, it can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped
It lasted 38 seconds. Phones really do that?
out of her sleep to come help, and her sister for some grand conspiracy.
Here he is getting angry again, smacking his hand down there on his notebook.
And so what happens is actually traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to hug John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time has anybody said, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened.
You think the occupants of 34 Fairview are going to talk anything about that? They try to stay away from 34 Fairview, and we know Matt McCabe said don't mention anything about the guy being in the house.
When they find their friend John, he's not 20 feet off the side of the road, like Mr. Lensler or Mr. Wolfbrook's. He's right there by the side of the road, close by the curb. Can we have slide 14, please? You can see there's Kerry Roberts in the middle, and then on the left, you can see where right up the road. That's not 20 feet. That is a foot, a stumble, and a fall. And remember when John Keith fell, there wasn't snow. It was just the beginning of the dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time.
You're the one that started calling it cold, hard ground, and no grass can't do it. He's not qualified to talk about that. Only a pathologist or medical examiner is.
All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass. That was up from the top. From the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried
Prove there's a collision first, Mr. Brennan.
the glass with him, leaving the evidence behind, a trail.
You don't even have any of the taillights being able to track to John O'Keefe via DNA testing.
Memorialize what happened to him that night.
What about all the glass in the bumper that was found there? Where's that coming from? It didn't match this glass. You're trying to say it was tied to John O'Keefe.
Remember the straw I asked you to take a look at that picture and we're leaving the waterfall 1212, the black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. You play the clip on the left, please. 59.
So when John got out of the car at Brian Albert's house, he took my full.
So
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you heard from some.
Jen McCabe did not make it sound like it's an urgent call. She never said it's somebody she loves. She never says a Boston cop. All those kind of critical details. She allowed the guy to hang up with her. She never asked, how long is it going to be till I get here? None of those kind of questions that you'd ask. She was not frantic at all.
Some of them, they were born to help people. That's what their life is about. The detail on all their mechanics, getting to work 2 hours early for no blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody, but to him it's another human being. This is his passion. Katie McLaughlin, first responder, this is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back?
McLaughlin, the one that you wouldn't let the photos of her hanging out with the Albert's daughter? You think the jury's going to forget about all the evidence you blocked in this case?
And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with this, so she has to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him.
Wish that was really true. Why didn't she get arrested right then and there? What'd she say she hit him with? Why couldn't anybody say that at the time? That's what she said. Why were their stories able to be embellished and exaggerated like that? Because they know that's what the government wanted to hear.
And these people are making it up. Anybody that says anything.
You can really believe somebody like Jen McCabe when she's spending probably multiple hundreds an hour on an attorney, has already had the FBI show up her door and she lied to them. You can really believe anything she said on this case. And Carrie Roberts, who's been led around, told what to say and do. And we know she lied to the grand jury, made it sound like she knew firsthand information, and when it actually was stuff that Jen McCabe was spoon feeding her.
Adverse or inconsistent or inconvenient is a liar or a perjurer. Are they in a conspiracy? Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up for the...
That's all he is, boogeyman Proctor? Really? A guy that had his hand on everything involving this case, that has connections to folks that are at 34 Fairview that night?
I know that doesn't reconcile, but the reality is you have independent core people who hear her say, I hit him. I hit him.
No, none of that's credible, Hank, and you know it. Those people are all discredited on cross-examination. Jen McCabe never even said that. After testifying multiple times over several years, only now has lately been adding that to her story.
And the attempt is to portray everybody as a lie. But you don't have to rely just on these good people, although you should. You should. You don't have to.
Portrayed as a liar? Oh, you're the guy that blocks impeachment evidence? Showing the connection with the Alberts? And you're going to stand up here and tell this jury that they're just do-gooders? They had nothing to hide?
Because we have a guide, and it's Karen Reed. Slide 17.
And you probably had, in this trial, let's see, you had 7 weeks of trial. How many objections did we hear an hour? I mean, there's probably over 1,000 objections in this trial. Are you blocking evidence? That's just a wild guess by me, but there's probably at least 1,000 or more.
So what you said was, did I know, and I always said, you know what, did I really say this many times as law enforcement's pleading and said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those.
Yeah, keep smashing that podium. Look like an angry man there, because you know you've been losing this case big time.
Good people exactly what they had heard. She tells you herself. She hit it. It's undeniable. It's
That's really getting irritating. Listen how loud that is when smacking the lectern like that. And he's pretty close in front of the jurors there. That's not proper for an attorney to be doing that. But what's he doing? He's desperate and he's angry.
unmistakable. It's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Miss McLaughlin hear exactly that.
Yeah, because their memory gets better over time, right? That's what's going on here.
And Jen McCabe, when she's sitting next to or standing next to Miss McLaughlin, she tells you she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, ironic thing is, you will see in a photo when Miss McLaughlin, the firefighter, was speaking to the defendant, Miss McCabe was next to her. Miss McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant from incriminating herself. The irony.
Yeah. You got a lawyer right away, right?
Can we have slide 9, please?
Zero, the lawyer got a zero.
This is the battery temperature.
Over.
You're gonna have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, you'll need the waterfall, 18 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it started to go down 72, 12:45, 66, 12:23, 61, and you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And his blood is still warm, either way, under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not a coincidence. That's data. And then it goes fast with the warm environment and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that's under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? And not only did the battery temperature rise, when you look at the healthcare data, at 6:15.
I've never seen a prosecutor or any defense attorney keep smacking their notebook on the lectern like that. That's really out of line. It just shows he has no control over his behavior here. He's emotionally out of control. He's desperate. He's not speaking with confidence. He's not talking about the list of different witnesses that talked about stuff about how the actual vehicle struck John O'Keefe. Can we hear that, Mr. Brennan? How did this vehicle strike John O'Keefe? Where's the evidence? You haven't talked about it. Look, we're in an hour and 33 seconds into your closing argument. And you don't bring up any of the details about how this was actually happening. You did mention nobody knows the exact details. We've already heard you say that, but what's the evidence you have to show that Karen's vehicles touched John O'Keefe's body and did any damage whatsoever? You have nothing.
When she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data.
All he's got is this different car data and phone data. He's got nothing to go on the real evidence that the jury needs to hear, which is, were these injuries in any way caused by Karen's vehicle? And the answer is a resounding no, no way, no chance. And if that's the case, you have no case. And he knows that. So he's going to wait till the very end to just try to discredit a few things. You're too late. You're hiding behind this evidence now. You're not talking about Lucky. And you just minimize all these damaging facts you have for the aperture witnesses as well.
So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in the cold. And there's Miss McCabe in her winter jacket.
Yeah, you think the jury believes Jen McCabe was really asked to do that? How long to die? You're out. Who thought he was dead? We heard from Jen McCabe's telling 911 she thought he was dead. That's what we know.
Her mom trying to help. She has MS. Her hands aren't working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then.
She never said she had trouble dialing because of MS. Where'd you coming up with that? I don't recall that.
Wants to run back to the ambulance.
If she's frantic making that call, how come she didn't sound frantic? She sounded calm, cool as a cucumber.
So she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did.
Louder.
And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock's porch.
All right, hold on a minute. No, just to clarify something. Yeah, they both have MS. Whoever said only Karen has MS. No, Jen McCabe says she has MS, so. Okay, JC, you're saying that she did say it. I'm not tracking that, so I'll stand corrected on that. I just don't remember that detail. She surely didn't sound like she was frantic on the phone about losing John O'Keefe.
Because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. But she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like Dr. Wolf from Harker knows how to do. This can't be erased.
Damage here.
But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way.
I'm just trying to get you mad.
Look at her. Look the other way. 2:27. Look the other way.
Oh, there he is, trying to copy the opening and closing for the defense, the last trial. That's real original.
Well, look at what she did. Former Trooper Proctor. Look the other way. Don't look at her.
Oh, that's so cheesy. I mean, really, don't look at Proctor. Don't consider that at all. You did not discuss one thing about how Proctor had the opportunity, means, and a motive to protect people he knew in this situation. He just glosses over that, completely glosses over that.
Every time they make those, oh, she got the glass from inside the outer, maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data, and it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction, disgust. Not saying you shouldn't be disgusted by the text messages. You should. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper Lieutenant was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances, to the President of the United States, now a state trooper.
Yeah, he's the one that talked about Proctor doing honorable work with integrity. Didn't he talk about integrity as part of the investigation? He said he did nothing wrong, yet he knew about all those messages, or at least a lot of them. Shows you what kind of botched investigation this was, and the actual bias, not just appearance of bias. All right, hold on a second here. I lost my spot. I got a small screen to work with.
He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But that does not, it doesn't create a conspiracy, doesn't invent a dog, it doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with.
You cannot say that. We got proof with Barros right there. Barros's proof. We got the video.
This was planted.
We got the video at One Meadows also to prove that. We also have other evidence as well. What happened to the Ring camera information from John's house there, where we had, what is it, a couple minutes erased there?
This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce three of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there's any evidence of tampering, not that there's any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove.
What we heard from the officer Dever, remember how she testified that Higgins was hanging out there with Chief of Police for a wildly long time when Karen's vehicle's back there? So why was Higgins spending all that time there at the vehicle? That's a massive, massive thing you won't talk about. I dare you to talk about it. You can't, because you know it's a gaping hole in your case, and it shows something else is going on there other than what you're saying.
This case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. when the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He's been near the car. And then the indictment videos themselves, when you close it,
Barrows saw it. There would have been a depression there. If that was knocked out, there'd have been a depression where the snow was there. There'd been snow and ice inside that thing. Look at how clean all the plastic pieces are of that tail light. None of them have any of the road debris on there.
take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? .507. You can play any angle you want, but if you look at this angle, it's gone. You know what I'm saying? It's already gone. You know where it is? 34th Fairview Road, on it in Reedfield. January 29, 2022, 823. Look at the right-hand side. Look at the left-hand side. It's back to snow.
And they also use different things that they had green light showing on a lot of this stuff as well. So you can't even really totally trust the videos that he's presenting here because so much of the stuff got compromised.
It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller. If you play it out and watch let's go up and down and slow it down, you will see it expands. It's gone. So when you have Indictment Officer Barrows come in here and try to tell you what he saw in the solid report, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail.
Okay, really? Well, what if they want to meet him face to face, make sure that he's credible? That's what attorneys do. You know that. Now you're throwing Barrows under the bus. That should offend some people on the jury. It really should. This guy, you could tell he's a man of impeccable character, and he had to speak against the blue wall of silence. For him to do that, now this guy, you're covering up part of the blue wall of silence here to discredit him like that and act like he's doing something sneaky by meeting with the defense. There's nothing sneaky about it.
And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face?
He didn't get red out, creep over his face. He's even a word that's creepy, creep over his face. You're just making stuff up.
Never said this before. In fact,
did you ask him if he had a ham sandwich with the defense counsel too? You missed that one, Brennan. My gosh, if you'd had a ham sandwich.
he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo with the snow, with it missing. And I say, is this the way it looked? That's, of course, before the snow melts out of the Sally Port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the Sally Port. There's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Terry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so, now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job.
Look at him discredit her. Sorry, dude, you've just really lost this jury. You're going to start attacking her motives, her character. You're really grasping at straws. Who'd you have to counter it? Nobody.
Wants to be here. Profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago.
She wants to be here. Why would she want to be here? She wants the charges dismissed because she knows you guys have no case. You're trying to frame her and calling dog bite injuries as being a vehicle strike injuries. So
That it's claws, it's teeth.
he's really going downhill here fast. Talking about this kind of stuff now, attacking her. You're not doing any favors here. You have to talk credibly as a lawyer about what issues you have with credibility of witnesses. If you're going to attack somebody like her as having a credibility problem, you're really far off the tracks here.
Teeth, and then it's claws, then it's teeth, and then it's I don't know. And then when you look at
It wasn't I don't know. She just said either way, it's from a dog. There's nobody that can know exactly which is which, but obviously it's from a dog with those type of patterns. It's not a car.
each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite.
And that makes total sense. And all you're trying to do is trick the jury into thinking she doesn't know what she's talking about. But that's all part of your misdirection. It's part of your gaslighting.
Dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it.
She's seen dog bites before. She's not had a testify in court before because it's really rare to find somebody that would question a dog bite. But no, it's you guys that are so whacked out crazy saying, no, something that's obviously a dog bite is not a dog bite. It's a vehicle attack.
And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yeah.
What? What are you talking about? This is like really shady what he's doing here. I can't even fathom that you're going to try tricking the jury like this, acting like she's just out there. Nobody else in the world could testify to this. No, it's just common sense. These are dog bite wounds or claw wounds. Who cares that you don't know which laceration is which? It's obvious collectively. It's whole. It shows that she doesn't have any bias.
After saying there's no punctures, Dr. Laposada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. Oh, is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously there is no science to looking at an abrasion.
Doctors can disagree on whether something's an abrasion or laceration or even a puncture. And so this is just a red herring. It's a nothing argument you have. They all know it's related to a dog, and you try to keep it out that it's a dog. So sorry, you fail massively here.
And saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have...
That's all you got to attack their credibility? Really?
Now, the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office.
That try to say that. See the spin he's putting on? It's all gaslighting here. He's got to put it on the pedal here for the gaslighting. He actually goes about 10 minutes more. He's only authorized less than 3.5 minutes here, but the judge doesn't cut him off. She wants to make sure he gets everything he wants to get in.
Office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed.
Because the injuries prove it. None of your wacky electronic stuff.
She doesn't know about the DNA. She doesn't know about the shards in the arm. or in the clothes. Strike that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she, in 90 days, saw a fraction of the information.
You try to beat her up with all those details. You know what? It didn't matter. Because she said none of that would matter because the injuries do not align with a car strike. He just can't handle the truth, Brennan.
A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle.
Yeah, didn't he say that they brought in some witnesses? No, you brought in Dr. Scortibello, so don't make her a defense witness as far as somebody being called by the defense. So somebody you called even torpedoed your case.
So the speed, some people can get plowed over by a car and have no injuries, some people can get touched lightly and have more injuries, and there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test, that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there's no car accident.
You don't need 90 days to figure it out. First time looking at it, you can tell this is not from a vehicle, it's from a dog on the arm. And there's no other bodily injury, there's no other facial injuries. If it's a car strike, his whole body would have been beat up and bruised. There would have been broken bones. Why don't you talk about the lack of any fractures on his arm, John O'Keefe's arm?
Let me talk a little bit about ARCA. I don't want to waste too much.
Why don't you talk about how you try to trick the jury into thinking that there was holes in the back of John O'Keefe's hoodie from being knocked backwards by a vehicle?
Time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert? What objective expert?
That's just so low. See, that's the thing. As an attorney, you would know that the ARCA witnesses are honest, credible. And if you try to attack them and go to this cheap shot type tactic, you've already lost your case. The jury doesn't believe you for 1 minute, but he has no ability to connect and resonate with the jury and know what a jury's thinking. So
uses signal, an encrypted app to communicate.
That's how you got to impeach him, is what kind of software they use to communicate. The defense asked them to use to communicate, that people all over the world use that because it's encrypted. And you were trying to get access to emails of the defense anyway. So, sorry.
About the case. Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8.
And that's why they did the faster test speeds that count for all that, and you're just doing nothing but gaslighting.
That's all, and because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic, and he fought me over and over again.
You smashing your podium, I'm sure the jurors like that, Mr. Brennan.
Did he seem objective that he was trying to help you? Because Dr. Rexel came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. So you adjust it. And he tried to talk.
Yeah, okay, yeah, Welcher adjusted, yeah. Yeah, like using cadavers, using tests from the 70s, 60s.
Talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on.
So you're implying there were sequestration violations. You know that you blocked the FBI being the client or the one that's hired ARCA to do the testing. This is so underhand and sneaky. That's what this corrupt court is about. Hide the ball, hide the truth from the jury, make them think it's some unknown, who knows what, but hopefully they can figure out that this actually is the FBI that hired ARCA.
On that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brennan asks you a question, make sure you're off the transcript. Impede the progress.
Impede the progress. Yeah, stop you from gaslighting and lying to people about what they actually said and tripping them up on it, putting words in their mouths they didn't say.
Slow down in the questioning. Interfere. Sequestration orders, it says, is fundamental fairness for all witnesses, not just some. And so what happens to Dr.
Like you talking to Burgess when you called him up and you represented the court that you just happened to get this out of the blue on the 14th of May when he really sent it to you on the 11th. I think I might have those date wrongs, but it's multiple days later when you informed the court, but you'd already talked to him several days before that and knew this was coming down the pike.
Renford, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him?
Yeah, 5 times because you kept browbeating him and the judge wouldn't stop you from acting like a tyrant like that.
In his testimony, not from the defense, from his former employer, he said, no, no, no. And at the end of the examination, he gives his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just asking him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes.
Okay, so what? So they said, hey, come by as you're leaving. Can we have a picture of you? What's that got to do with anything? All those people standing around, he's going to have a conversation of substance. What's your point? It's just all drag people through his ringer of mud, but it's not working. It's not working, Brennan.
And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what?
Oh, really? Okay. Well, gee, let's go back to that. There was no more. Is there any gaslighting going on with that, folks? Let's see this here. Hold on a minute. I'm going to the trial channels, the direct of Dr. Judson Welcher. Stand by here. So here he's bringing up his own expert. Think about this, guys. He's bringing up his own expert, and he's already over his hour and 15-minute allotment. So he's going to go a few more minutes. And that's the first time you bring up your expert. You know you got serious credibility problems with your expert when that's what you got. It's just the last couple of minutes. You're going to bring this guy up. So let's go back to that. So let me remove him. That's the 116.27. Okay, so this is the direct of Dr. Judson Welch, as I said on the trial channel. And look after, hold on a second, got to share it first. Oh yeah, here it is. You can see it. So look at this now. Right after they're showing up for the jury to see these dog bites and scratches on John O'Keefe's arm. Let's see what he goes in.
From your shoulder to your elbow, and then from your elbow to your wrist is your forearm, and then this is your hand. So technically when you say arm, it really means from your elbow to your shoulder. Most people call this whole thing arm. It's actually the upper extremity. Arm is from shoulder to elbow, elbow to wrist is forearm and hand. So you can see I wrote arm and forearm. So arm, elbow to shoulder, elbow to wrist.
Actually, he's wrong on some of that stuff, guys, because he's the actual inside of your arm between your elbow and your wrist. That's your forearm. The lower arm is on the outside. So he's actually wrong on that.
Is forearm. So looking at the injuries to Mr. O'Keefe's arm, forearm, as well as his hand. So this is me. I'm actually 6 feet, half an inch tall. What you see in the upper right is the coroner's examination report for Mr. O'Keefe. He's 73 inches tall. That's 6 feet, 1 inch tall. At this time, I was 220 pounds. Mr. O'Keefe at the time of this incident was 216 pounds. So
So he's trying to recreate this. That's what he's doing here, guys. This is what he did to the jury on direct. Now he's walking it back with Brennan because they realized how embarrassing this was and it blew up in their face.
measurements of myself. I'm actually wearing the same make and size shoes as Mr. O'Keefe, the same brand of jeans as Mr. O'Keefe, the same brand and size shirt of Mr. O'Keefe. You see the Lexus in the background.
Everything's same. It's a replica.
We have matched the height to the Lexus. What I'm showing.
He's an engineer. He's trying to recreate what happened here. Isn't that the purpose they called him, to try to recreate what happened?
Showing here is both my height, and then keep in mind where the height of this wing is relative to my right eye.
I mean, this is like exactly to T how you'd be describing it if you're trying to replicate it, right? He's even dressed like John O'Keefe, which is really creepy, but.
So now I'm wearing, in addition, the same shirt and shoes, same type of sweatshirt, and actually the same kind of baseball hat.
Same car, exact same dress as John O'Keefe, near similar height and weight. This is a replica of what they're trying to say happened to John O'Keefe. That's the whole purpose that you did this.
We tried to determine the exact glass from the Waterfall Grill. Found out they were getting different ones at different times, but I ordered my glass from the same distributor that Waterfall Grill ordered their glasses from. So
sounds like an accident reconstruction, an actual live demo, exactly how he got hit.
you can see in my right hand here, I have a glass. Here's a glass. It looks similar. It's from the same location. And then in the lower right photograph, what I've done is I've rolled up my sleeve, taken the sweatshirt off, and I'm going to look at how this contact pattern lines up. So the first set of slides, I'm simply...
He's doing the lineup to show exactly how he was hit. So you can talk about angles and lines. Well, that's the only reason you're talking about angles and lines is to show how he's hit. So he's doing double talk in the same sentence. Talking about back to Brennan.
Standing next to the Lexus, we know we have a broken taillight. We know how scratches on Mr. O'Keefe's arm. I'm seeing how those may or may not relate to the height and position of the taillight.
Dr. Welch, if you could back up one slide, I have a question for you. In the middle photograph, at the top of the Lexus, there's like a rim. What do you call that?
I call it a wind wing. I mean, it could be a wing.
Okay, thank you.
Air dam would be another. Okay, so I then set about to do a little bit of testing with the Lexus. The first test you're going to see is me just walking backwards, or actually sideways, into the Lexus. What I've done is I've painted the Lexus
Why would you do that unless you're trying to recreate what happened? You're trying to see if this is how the injuries would have happened.
right rear tail light with what's called grease paint, and sort of like paint, but it doesn't dry. And then I have backed up sideways, side shuffled into the Lexus with my arm out, see what the damage pattern looks like, or basically where someone of Mr. O'Keefe's height's arm would contact the rear tail light. So then what you see is I've shown the photographs again. I show the paint transfer onto my arm. The yellow grease paint on my hand was to show where my hand would hit the taillight. And so just kind of me walking slowly sideways into it, the approximate location of the taillight, and I'll line it up with the broken taillight in a second, lines up with the approximate location of the lacerations on Mr. O'Keefe's arm.
Dr. Welch, let me ask you a question. When you're engaging these demonstrations, are you attempting to try to show exactly how Mr. O'Keefe was struck?
No. So we don't know exactly how he was struck, and pedestrian impacts are extremely sensitive to exact angles. And so where exactly your foot is, whether your foot's off the ground, can have an effect on.
So he's walking it back, but this is exactly what he's trying to show here, right? By dressing up exactly at him, he's trying to plant in the jury's mind, this is the only way he could have gotten hit and killed, is what I'm demonstrating right here. So he's trying to walk it back because nobody could tell him from what happened to the scene there. There was no videotapes of how he would have gotten hit and all that kind of stuff. So he's admitting that they don't have any details because he knows he's going to be asked on a cross-examination, but he's just making it look like all this happens to line up. I'm not saying this is how it happened, but all this lines up just perfectly. Look at this.
On where you end up after that. We just don't have enough information in this case to determine all that information. We know the taillight was broken. We know the glass was broken. We know we have damage to the rear of the Lexus. We know we have lacerations in Mr. O'Keefe's arm.
Okay, but you know what? He went on to say this vehicle, Karen's vehicle, did strike him. He didn't say it was consistent with the vehicle strike, these injuries, but he did say that and make it sound like this is what happened, that Karen's vehicle struck him. So he never said exactly how it happened to the detail, like where exactly he's standing in relation to the curb, how he got in law. None of those details he could know about, but he dressed up like the Blue Man to try to be able to pin this on Karen Reed. So it is abundantly clear. So for Brennan to walk that back, I think it's just a matter of he realizes how much this has been blown up in social media, making the Commonwealth look like pretty ridiculous here. All right, let's see. I'm trying to. Back to StreamYard. I'm not seeing StreamYard here. Here we go. I found it. Okay, let's go back to the last part here.
They do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that. And his work on texturing data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably,
What about your
proof, without any doubt, that on January 29th, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk.
What about Dr. Lapizada? Are you going to mention her?
She drank. She was 2 to 3 times over the legal limit. and they went to a party, an after party, and they were fighting. There was a relationship in decline. And he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have...
Yeah, and you got no proof of it also. There you go. Thank you, Mr. Brennan.
a good idea from the physical evidence, and we know that it happened. Can someone have...
We can't prove how it happened, but we know it happened. We don't have any physical evidence lining up with this. We don't have any medical information and medical knowledge. We don't know anything. We have no idea how he got out there. A lot of people acting very suspicious. A lot of people got lawyers. Even the FBI or ATF lawyer, ATF agent Higgins got a lawyer. You had to interview him in his lawyer's office. That's how shady these people are. What are they hiding?
A collision without lower body injury?
Why don't you address that? Why don't you address all that stuff? He's not addressing really anything. It's all just smoke and mirrors. The stuff he is trying to pick apart for the defense witnesses, including his own witnesses, he's not making any sense on. And that's a sign of a losing case here.
Could I have slide 19, please? You bet they can.
The judge should be having a timer there and cutting them off. Yeah.
We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on...
Yeah, what about the x-rays, buddy? Why don't you talk about the x-rays? That guy's arm would have been obliterated. If that was a human being standing there going that fast, their arm would have been obliterated with broken bone.
that curve.
You'd had shoulder damage, elbow damage, wrist damage, hand damage. If you're holding the glass, your glass would have been cut up.
Lodge against the sleeper.
An absolute
To show he then falls back.
story.
Hits his head, counter coup, left to die.
This is somebody's wife on the line.
Thank you.
That's it? Wow.
Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Miss Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%,
I thought it was over.
whether she meant to hit him or not, didn't mean to kill him, she hit him. Straight, it is a plain and strong likelihood of death. You would never get back down your driveway if your kids were at the end of the driveway. You would say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she's reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please?
Keep on the podium.
He is not an it. John O'Keefe is not a body.
You guys do.
John O'Keefe is not a buffalo on a prairie. John O'Keefe is a person. And he got murdered by Karen Reed.
Thank you. All right, jurors, the next up is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today.
If you guys could give me a break here for a second. Go ahead, chat, if you guys have any questions. I'm going to cover the verdict form or slip. So if you have any questions, get ready for those. I'll be right back. All right. Let me go ahead and find the verdict form. There's a few things on there I want to discuss, and if you guys have any questions. Thanks, Kim. I see you sent some as well as Sherry and Stevie. Appreciate that. Uploading now. Okay, here we go. So this first one, verdict slip. So this is the first charge, murder in second degree. In the above entitled case, the jury, say the defendant is not guilty. Now, is guilty offense as charged, murder in second degree. Unanimous decision, all 12 members. Okay, this one's not very complex. It doesn't have any instructions what the elements are for second degree murder. And those are obviously given by the judge, but if they have questions on that, it's not all readily handy for them. All 12 members don't have to sign. They can ask to have them polled if there's a verdict of guilty for any of these charges. Then the defense is always going to ask to have each of the members stand up and affirm that, yes, this is their accurate and true verdict. So this one here, it doesn't say that they have to pick one or the other, but it's not as confusing because there's just two options. I think the people know on the jury that they need to pick one or the other. But then when we go to the next one here, look at this one. This one's like sort of really convoluted. So this is manslaughter while operating a motor vehicle under the influence of liquor. And so here you have 5 main blocks to check. And the first one, I always think it's important to have the first option for the jury to select on any charge is not guilty because you have a presumption of innocence. So not guilty of that offense charge or any lesser included offenses. Lesser included offenses are ones that have some of the elements of the main charge, but not all of them. And there's no added elements to those charges, but there's lesser. It's just taken away some of the key things you have to prove on the more serious charge. So the lesser included offense. Well, what's weird here is like you got not guilty of this charge, but then you have guilty offenses charged manslaughter while operating a motor vehicle under the influence of liquor. Check one or both. Probably. Then it says the exact same thing again: manslaughter while operating a motor vehicle under the influence of liquor, and or. So it says check one or both of the following. Is it really telling them that they can ignore? Like if you can go, if you go to block 1, you're done. If they want to elect not guilty, they really know that they don't have to elect any of these others. They don't have to check anything on them. So it should be clear here, not guilty to offense charging unless include offense. If this is your verdict, then skip 2 through 5, something like that. Let's see here. Now we don't have the actual elements of these lesser included offenses. So all these have to do with operating a motor vehicle and involving a death of someone else. So that one, the fact that number 2 is repeated twice is just really strange. But I guess they have to make a decision on whether it's under the influence of liquor versus whether it was 0.08 or greater. So what that generally means is the latter one, at the 0.08 or higher, means that the jury's relying on some kind of blood draw or breathalyzer test. That's the way they would check that one. And for the other one, they're trying to say if they're under the influence of liquor, such that they don't, and they'd have an instruction on what do they have a loss of their mental and physical faculties. They have to do a description of what it means to be under the influence. So if they don't have any, like for example, somebody refused to do a blood draw or refused to do a breathalyzer, and all you had is their mannerisms and the way they drove and things of that nature to show that they're drunk, their slurred speech, they're falling down, can't walk straight, all those kind of things. That's what they would check as the one above the one that says 0.08. Now, if they blew in the machine also back at the police station, then they could check both of those, right? So that's what this generally means, but I wish they'd clear it up better in terms of like the overall check. If you check the first one, you don't go on to any of the others. And then they have involuntary manslaughter without any guidance there. But that is a lesser included of manslaughter while operating a motor vehicle. So that one doesn't involve a motor vehicle. Then you have guilty of lesser included offense, motor vehicle, felony, OWI, and liquor and negligence. And then this is involving the same thing as before, under the influence of alcohol or 0.08 or greater. So it's basically a drunk driving involving liquor, and it's involving negligence. So it's not as reckless as the other ones above it. So they're lowering down the degree of culpability. So this mere negligence is what that one would be able to attach and find someone guilty if they proved it. And then the last one, the fifth one they added, that's not the one they had from the previous trial, trial one. That one's just generally drunk driving. And this is something that I think is good to have on there because it's a way to allow the jury to find something, like if it's a way to horse trade some kind of charge, because some jurors say, look, we got to find her guilty. There's something she's guilty of. I'm just not going to walk away and not find her guilty of something. So there's something here that it's only a misdemeanor. She shouldn't serve any additional jail time on it. And so that's something the defense asked. And I think it's a smart move. I think one of the things I would also ask to do is because if they're saying it's second degree murder, that's the highest charge, back to this charge one, there are lesser included offenses of murder. It could be something like aggravated assault. It could be something as simple as assault and battery. So that's, if they're saying she just, like even Hank was saying, could she have clipped him and stuff like that? Well, what if she clipped him and thought she might have known about it, but didn't really know, and, didn't intend to hit him? All those kind of things could fall into the generalized assault and battery kind of instructions. So no one's asked anything about that. So that's not coming to the jury was not instructed on that at all. And this last one, the verdict slip is count 3, which is leaving the scene of an accident resulting in death. And so that one's not guilty and guilty. So this one is not such an issue. What I would have asked for is to have every single member of the jury sign this form, not just the foreperson, because foreperson, as we saw in the first trial, can wield a lot of influence and bad influence on the jurors. So with that, do y'all have any questions on these verdict slips? Yeah, I wonder, Kim, it's okay with numbers. I guess if you had instructions above saying you must select one of the two below, between numbers 1 and 2, you must select one, check one option as your verdict on this count. Yeah, I do think that the second one has got that so many different options, but those are all lesser includeds of that higher charge offense, the count 2. Yeah, I just think it's better if they have a description of the elements at least on there, not all the instructions, but at least what the element of that is. Just they're just not going to remember all the verbal instructions. Yeah, so I think this whole thing is, I was thinking that based on the weakness of the evidence, the jury would come back Friday afternoon. And Friday afternoon, though, they were only out there, what, an hour and 41 minutes, and the judge pulled them back in. What they were thinking they had the ability to go to maybe till 5:30. After all, the judge was talking about how much she wanted to get this to the jury, and then you reel them back in so quick, and they didn't even know. So maybe they already were ready to, like, they're going to the final stuff, and maybe they're thinking, hey, we got till 5:30. Okay, 4:45, we'll do our final vote and tell them not guilty across the board, or whatever their verdict is. But in any event, this went much later. So if they got this so late in the game, I said they would have a verdict by 5:30, assuming they went out at noon. 5.5 hours of plenty of time. So I think still within that 5.5, 6 hour window, we should have a verdict then on Monday. Yeah, Jared, you want to talk to the jurors about how stupid the case was, and maybe you'd have enough time, just want to get it over with, so you go home. But then you're pulled in there suddenly and didn't realize that the jurors were not able to deliver anymore. Plus, this whole issue about the foreman. The foreman was selected before they called out the alternates, which is something that, as I've heard, has never been done before. So that really looks like things are being manipulated. Plus, I thought that the judge doing that instruction on prior bad acts for the Aruba situation, I mean, that's for criminal type behavior, not some argument. So I think for the judge bringing that up was like really an act of desperation, trying to highlight something that's really nothing. And so, hold on a second. I might try to play that part if I can pull it up here. Stand by. Okay, stand by. So listen to this here. I'm just going to play this one part about the Aruba.
Limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interaction.
So right there, she's not charged with other crimes, and then she's going on to say, like, hey, you heard about other crimes that she committed, right? So this is very loaded, tricky, and underhand, I think, to try to highlight this thing out there, because it's not a crime. There's other bad acts. It's talking about other stuff that's like criminal law related. You could have been arrested for it, not been prosecuted for it. You could have been found not guilty of something after you went to a trial. It's like something that's a criminal act, not something that's just relating to a disagreement, an argument, and her yelling at him in front of a lobby. So this looks like an act of desperation to bring out something that's not a crime. I've never heard of this being anywhere in the states I'm licensed as being something other than a crime. And so this is under like rule of evidence 404B in the federal rules, and most states, they have similar 404B rules, which is prior bad acts to show intent, modus operandi, things of that nature, to show this really a signature earmark kind of way of handling things. Here, let's see what else she says about this.
Actions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as
What's her interaction with others got to do with anything about these charges and finding her guilty on this?
evidence of the nature.
Because she's argumentative with people, or she's mad at somebody that she thinks is kissing John, that somehow she's a criminal?
Of the defendant's relationship with Mr. O'Keefe, and whether it goes to her knowledge or intent or motive.
Knowledge or intent or motive. So getting mad at John in Aruba prior to the 28 January incident. Knowledge of what? She doesn't explain this. It's really bizarre. So let me back this up a second. Listen again.
The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive.
Knowledge of what? Okay, that he's cheating on her, I guess. So, but it's not a bad act.
On January 29, 2022.
Knowledge of what? It doesn't make.
You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute.
Bad character. This is bad character, her getting mad. And this is like making it look like it's criminal, right? This sounds like to me criminal. I've never heard of it being anything other than criminal. So in Massachusetts, there's something different here. It looks like you're trying to really make this person out to be a bad criminal, and you're highlighting stuff for the jury, but saying, oh no, don't consider it for, as a separate crime to charge them with, but still consider it
For proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe.
What? So that's a bad act? The fact that she got mad at him because she thought that he was kissing somebody else in the lobby? I mean, come on. It's really bizarre. I've never seen like it, and the judge wanted it. So I think it's just a way to highlight the Aruba thing. Really strange. Don't get that at all. Sometime you think it's Monday, 3:30 or 2:30. You think the judge is listening to deliberations? I mean, there could be some law enforcement right outside the room listening. Monday, 2:27 to send a message. Yeah, Kale. So anyone can have prior bad acts admitted then for any disagreement with anyone prior in the incident. Yeah, if you're charged with some kind of assault on them, I guess any prior argument you had with them, if you're justifiably angry at somebody, that could be considered a bad act. So just mere anger is a bad act. PJ, no collision in the end. Yeah, that pretty much sums it up. And you're saying the jury knows better than to trust her. I hope the jurors can. I think they obviously see what's going on with Brennan, and I think they see the judge is doing everything he can to help him get this conviction. Yeah, there's no violence there. If she would have gone up to him and hit him or something like that, that could be a bad act because that could be assault and battery. But just mere having an argument, being mad at him. Yeah, Jane Ferguson, you thought prior bad acts was always meant criminal acts. And like I say, just say it some lights, it could be something along the lines of, it has to be a crime, whether they're charged or not, arrested on the spot or was reported to police. All that doesn't matter. What matters is there something there that links it to this kind of charge that she's facing in court today? And there's just nothing there. The fact that she's mad at him. Okay, well, they have other evidence that she was mad at him, and she was justifiably mad at him. Ricky Shea, you're saying you presume the foreman's order was not included in the draw tumble. That's my understanding, is that they would have pulled his name out. So all right, so overall, let me go back though to the closing for Brennan. I think I'll say, I guess in terms of what he did good, I think he didn't rely on his notes too much, but in terms of the delivery of it, he seemed to have a pretty good command of details, but he did so much spin and all that fist pounding on the lectern and smacking his hands together to make some startling noise like that. I think that it's pretty much the way he was wandering around meandering on his argument. It just did not come across well. I don't think he's convincing the way he argues the case. And I just think that he doesn't come across like he really believes his case. Jurors can pick up on that, whether you believe the case or not. And you know what? If you got a strong case, you can take on and mow down everything the defense is doing. Everything the defense is doing that you think is that they're trying to poke holes in your case, you can counteract it, and you can really, in a critical fashion, in a logical, coherent fashion, pick it apart, expose all the flaws in their argument, and with their witnesses and evidence. And here, he didn't even lay a glove on any of these critical evidence pieces that we had in this case. Stuff like, he didn't even mention Lucky at all. He didn't mention people in the house. He's not mentioning a lot of stuff. He's not mentioning what happened to the blood. He can't account for so many things. He admits that they basically can't explain how exactly he died. He's walking back to stuff with Welcher, and obviously he's trying to use Welcher to explain what happened to John O'Keefe. That's why he dressed up like him. If he wasn't trying to dress up like him, why would he try to, trick the jury that way and then backtrack and say, "Oh no, we're not trying to show you this is how he died." Well, then if you're not doing that to show how he died, then you really don't have any idea how he died. And your experts can say anything. You're just going to rely on some kind of like phone stuff and some kind of black box in a car that even doesn't show that there's a strike at all. So I don't trust these numbers that they talk about. Anyway, the 1162. How do we know that's not back at the Sally port? How do we know there wasn't other drivings, other vehicles? If you count the different stops that they made before it was brought to the Sally port, between Karen driving it over to her parents and them loading it up on the truck and them driving it off the truck onto the Sally port area. There's any number of these things could have happened. I just don't trust that kind of data, as he's trying to make it sound like it's absolutely flawless. Liz M., you're saying, did y'all hear that 2 jurors think she's an evil woman? I missed that. I haven't heard anything about that. You talk about some alternates? Have some alternates said anything yet to media? Piggy Doo, you're saying if she gets convicted for the DUI, can they overturn it due to all the misconduct? This misconduct had to do with a lot of the other charges, but I think there is a chance this could be reversed as well due to the lack of having a properly certified lab at the hospital. Yeah, Kay Reggie, you're saying since she always picks seat 1, she moves a person she wants into seat 1, and that number 1 is never in the pool for alternates. Well, and the one that she moved in seat 1 is not taking any notes. I don't know what to make of that. That could be something that I would not want to see if somebody just sits there the whole time. It depends what his body language is. I think it's a guy that they're saying. Sailor, you're saying it's mean and violent closing. Yeah, there's just too much aggressiveness. He had not connected with the jury the whole trial. He's just wandering around lost in his opening, both in words as well as in the room, is pacing forth and back, like he's trying to get his mind around what all the details were. Yeah, the sweatshirt. Yeah, I don't recall him mentioning the sweatshirt either. That's a good point. He doesn't mention all these bad things, and the comments he made, like, you're going to attack Arca? You think you did a good job attacking Arca? Give it up. Listen, how's it legal that the judge gets to choose the foreman before the alternates are picked? This allows her to guarantee one juror she wants to make it on the jury. Yeah, it does, but you know what? That's an appellate issue. You can't do anything about it at this level. So only if Kieran's convicted is that it become an issue. So Scorpion, you're saying Brennan argued emotion, which is not evidence, and juries especially told to the jury not to base to base a verdict on that. Yeah, I agree. Yeah, notice Brennan never thanked the jury, unlike the defense. He doesn't respect them. He doesn't treat them as like with the dignity and respect they're owed. I mean, why would you gaslight people nonstop? Full life values, you think 1162 was a tow truck driver driving it onto the truck. Yeah, baseless attacks on these honorable people. The one he didn't attack is Lopez Orta. Remember, he's worked with her before, so he probably doesn't want to attack her character on the closing argument here. If he goes back to doing defense work. So it's getting late here, so I'm about ready to sign off here. I'll take one more question. Thanks for y'all for following this case. And I'm thinking about maybe doing the closing for the defense tomorrow night. Serial 08, you're saying Hank's closing was forget the details. You know she's guilty. You can feel it. Yeah. I mean, not bringing up any of the scientific evidence, what they testified to. That's all you got. He cannot talk about and deconstruct what Arca did. All he did is attack their character. If you do have to do a character attack on those guys, as brilliant as they came across, as much science as they brought and engineering they brought to the table, unlike his Aperture guy, it's unbelievable. And like I said, I think the best thing was he absolutely destroyed Welcher because he said there's no way you can actually ever figure out how John got there, and you can't find out what hit him even as well. So Rentschler was awesome on that. Him and the last two witnesses were like the greatest, Rentschler and Lopez Orta. Ricky Shea, the jury can decide the veracity of witness. Can they also decide the veracity of prosecutor? Well, that's what they take into account. Yeah, there is some. You carry some baggage in your case if you think you can just treat anybody the way you think you want to get away with, and judge lets you get away with. The way Brennan was acting in this court, I've never seen anybody act so ridiculous, just out of control. And there's going to be there should be accountability for that. If they don't trust them, they don't like them. You can otherwise have a decent case to win, but if the jury is turned off by you and your bully tactics, they should drop kick your case out of the courtroom, find the defendant not guilty. Thanks for my mod tonight. I think she was on here. Food is love. So thanks for your support. And TBD on whether I go again tomorrow night for the case, but definitely hope to be covering the case back on Monday as well, because I'm really expecting we'll have a verdict by Monday. So with that, I'm going to go ahead and sign off. You all be safe and see you again soon, hopefully.